These recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstance related to state's witness Kenneth Copeland. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan, appeared and indicated in open court that Mr. Copeland did not wish to testify and intend to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effects of an immunity over. Judge Glanville discussed with him the effects of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Judge Glanville specifically advised Mr. Copeland that if he invoked his Fifth Amendment and refused to testify, the state would ask for Mr. Copeland to be held in contempt, in jail. Judge Glanville also advised that if asked, Judge Glanville will jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the Fifth." Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was held in contempt and ordered him jailed until Monday, June 10, 2024, at which time Judge Glanville told Mr. Copeland that he would revisit Mr. Copeland's willingness to testify. Mr. Blank spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated that he would revisit the issue with Mr. Copeland on Monday, June 10th, 2024 at 8:30 a.m. The court was adjourned for the day. On June 10th, 2024 at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adriana Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and were not aware of the meeting taking place. The transcripts reflect that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation, Ms. Bumpus. Ms. Love and Judge Glanville also discussed the scope and the effect of the state's grant immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers where he spoke with and asked Ms. Bumpus, Judge Glanville, and Simon Holton, counsel for the state who had joined the meeting during that time. The state advised Mr. Copeland that he could remain in custody until the conclusion of the trial of all defendants in this case, not just 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibility after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. After the meeting, and immediately before Mr. Copeland was brought out to testify, Defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chamber meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. Though Mr. Steele was allowed to remain in courtroom on behalf of his client, Defendant Williams, ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later ended, setting July 1st, 2024 for an in-camera review of transcripts of the ex parte meeting. The first motion to recuse filed by DeMonte Kendrick on June 12, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the alleged improper and coercive ex parte meeting with the state. On June 14, 2024, Judge Glanville denied the motion. Judge Glanville determined that the recusal motion was timely, supported by an affidavit on their cursory review, contains assertion of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chamber meeting, the affidavit was lengthy, insufficient, and the motion to recuse did not require referral to another judge for consideration. On June 14th, Caleb Bumpus then filed a motion to squash the show cause order and or to recuse Judge Glanville for presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17th, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorced from his hyperbole, Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleged was improper and cohesive. Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer Brian Steele in contempt. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking justice notice of in making a record regarding contained matters associated with the ex parte meeting. Most of what Judge Glanville relayed was a correlation of record evidence and the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for the ex parte meeting. In addressing the circumstances of contempt against Mr. Steele, Judge Glanville explains the court purpose and concern in pursuing information about the security and the confidentiality of his chambers. Judge Glanville advised that he did not instigate an investigation into surveillance footage, but had reviewed such footage for timeline and security. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such meeting. Judge Glanville maintained that no one gained a technical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that recusal motion filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.2. The motion to recuse were then assigned to this court for consideration. Motions to recuse are governed by a specific legal framework outlined in Rule 25. Of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit clearly stating the facts and the reasons for the belief that bias or prejudice exists. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the case to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the priority proprietary of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed were inherently improper. However, in this order, denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decision and actions and argued why those were proper. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective. Such a disclosure must be made in a way that is as objective. Such disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting this record as a recusal issue in a ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations, mandating his recusal. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motion were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case.